Welcome everyone to this Privacy Espresso series on the EU regulatory framework. Today we are going to discuss together with our expert from Germany, that is Volker Wodianka from the law firm of Wodianka Legal. And we are going to speak about one of the many laws we are facing in relation to data in general, that is the Data Act at the EU level. I think that this is very interesting because it's a bit different from what we are used to discuss in relation to privacy and data protection, and in particular to personal data, because we are going to focus in this case more on non-personal data and see which are the relations and the intricacies of dealing with this kind of frameworks. But I will leave it to Volker that will explain much better what I was just going to give an overview on. So Volker, thanks a lot for being with us. And can you introduce us, providing an overview on which is the scope of the Data Act in the context of the EU laws and frameworks?
Thank you very much, Alessandro. I think it's worth to mention that we talk about the regulation, so that will come into force in the EU as it is in, of course, different languages, but as we know from GDPR, a regulation directly applies in the countries. So harmonizing the area of using data and explicitly not personal data is something quite new. And it's basically about making data generated by the use of a product or related service available to the user. And we will come to some requirements and so forth just in this short meeting. But what we maybe see as a parallel to GDPR, apart from the fact that it's a regulation, we have the market principle again. So even if you're based outside of the EU but address the EU market, this new regulation will apply in the future. And of course, it's super interesting to see definitions of personal data and non-personal data. The idea of anonymizing personal data to be out of the scope of GDPR, but now realizing, and we expect more or less 2 years until it's then enforced, this new regulation, that then we have a data act that regulates non-personal data is, of course, super interesting and will bring up many questions, I'm sure.
And that's very interesting because, as you were mentioning, all the data that we anonymize to be compliant with GDPR then will fall within the scope of this act. Am I right?
I mean, part of the scope is definitely also that not every size of a company will be in the scope from the start. So first of all, it's of course the bigger companies and mid-sized companies. More or less 250 employees is the threshold there, but smaller companies will not be addressed as such. But again, knowing your data is the key, is more or less the key in order to be able to react to these new requirements, no?
Yeah, and makes sense because basically you see that there is, some sort of connection between the various regulations to protect companies and all the type of data within them. Which are, in your view, the key requirements to comply with this law? Some seems to be similar to the GDPR, some other are different, maybe different.
Yes, again, the idea of access rights is quite well known by GDPR. So delivering data also to the user in the terms of interoperability is also something which is always a little bit pushing the market, so that people are not bound to a device as such. Now, when we talk about the product, how can I release my data in an application, move it to another application from another provider, possibly a competitor, is always competition friendly, but poses, of course, requirements from the technical point of view that this is actually possible. Also, information, that's something that we all know from GDPR, information on what data is being processed for what kind of purposes is in there as well. And also worth to mention, the third country data transfer that we all know from GDPR, Schrems 2, adequacy decision, and so forth, is also regulated in the new law. as an information duty, and also one that, and it's interesting to see what we can do there on the formal point of view, how to protect the data transfer into third countries. Of course, we don't have EU standard contractual clauses for non-personal data, but it also mentions agreements and technical and organizational measures as a requirement.
That's very interesting. And I think we were discussing about this in the past, and I think you also mentioned something on in relation to the public authority access right.
Yes.
Was there something on that may be interesting?
Yes, and this is again something or something that we kind of know as a big concern in third country data transfers, so that there's a public authority request for data, but that we do not know so much in the EU from the EU perspective regulation. Of course, many countries have their also security authorities, agencies that can request data based on maybe a court decision or so. But in this regulation, it's, as far as I know, very unique that under special circumstances, authorities can require access to data from a company. Under certain circumstances, basically, that's how it reads. It's, let's say, for the good in emergency situations and in situations of public interest. But still, these are, of course, definitions that could be also used differently or should be discussed in the future, because companies are usually not really happy to reveal data to authorities. For the good, of course, to support in emergency situations is not really a problem. But yeah, then defining what about our secrecy rights, about our know-how, or could that also be touched? And basically, I can tell you that, of course, bordering laws are respected. That applies to GDPR as well as to laws on companies' secrets. Still, there might be overlaps, and I think that's the interesting factor, how to separate those kind of data and accept them from the authorities' access.
Okay, wonderful. Thanks a lot, Volker. And the classical question when we deal with a new act or a new framework is, which is the risk of fine and which kind of fine are companies going to risk? And since we have like 3 minutes or maybe less, I would also ask you, out of that, which are the do's and don'ts that in your view companies should do when dealing with this data?
Yes, sure. Of course, when you violate a regulation, there's always huge fines, and that will be the case with the regulation as well. So it's always good to be prepared. And what I think you should do, and that's, let's say, what I also do in my role of an external DPO, to inform early enough the stakeholders in your companies about the new act, about the Data Act. Show them the topics and requirements that do overlap. So when you do already good technical organization measures on personal data, why don't you think about doing that also for other data that you see should be protected? And also when you think about information to customers and you develop products and services that collect data, make sure that you early enough involve also the teams that work on these features, that they're able to be transparent and give you the right information in order to fulfill the requirement. So I see more like a lot of good arguments for the existing data privacy organizations to show what needs to be done in terms of documentation and transparency, to also fulfill the new requirements that we see with the Data Act.
Perfect. So basically we can have some sort of lesson learned from what we have been witnessing and learning over data protection measures, and we can apply part of them at least in these regulations to make life easier, because it's something that we already know and we already do. So that's a great tip, I think. Volker, thanks a lot. We are running out of our time, so thanks for being with us. I'd like to thank also our listeners for their participation in this session, and I look forward to meet you and all of them with our next Privacy Espresso. So bye, everyone.
Thank you, Alessandro. Bye-bye.